This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing and Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, it is now time for Ask Todd, where you, the listener, can call into the studio and have any and all of your estate planning question answered by Todd Lutsky. If you want to give us a call, you can reach us at 888-205-2263. Again, that's 888-205-2263 to have any and all of your estate planning questions answered by Mr. Todd Lutsky. Todd, how are we doing today?
I'm never better, and you?
I'm doing all right. I've licked my wounds from the Celtics loss. We're moving on, and we're just going to enjoy the beautiful May weather that we're having here. Question for you, Todd, regarding wills. Oftentimes when you talk with clients out there, they're very focused on, do I have a will in place? Do I need to make changes to my will? What is your viewpoint on the will and sort of where it stands in terms of a general estate plan? Does it cover all the bases, or is there more work that's necessary to be done for most folks out there?
I think if you're starting with the idea of just having a will, I like to tell people that it's a won't, right? A will is really a won't. Well, why would I say that? Well, think about what your objectives might be when you're doing your estate plan, right? First of all, do you want to avoid probate? Well, the answer generally is yes. Mm-hmm. A will won't do that. In fact, remember, a will goes to probate. It's the only item, the only estate planning document in your toolbox that actually has to be filed with the court. So that's going to probate. What is probate? Probate is items that you die owning in your own name. If they're in your name, they're going to go to probate unless they're in your name alone is really the answer. So a will won't avoid probate. Number two, I don't want to pay death taxes. Mostly clients don't want to pay either estate taxes at the state level, which check with your state, or more importantly, the federal level. Again, that number is a moving target, as we know, but right now it's pretty high, so that might not be the biggest issue. But we certainly don't want to pay taxes, and I can tell you a will won't do that. Starting to get the flavor that a will's a won't.
I hear you.
Well, there's more, though. What about if I want to protect assets from the cost of nursing home care? That might be another general question that clients have. So if I want to do that and I only have my assets in a will, it won't do that either. So a will is really a won't. I think the only thing the will really does for you is it directs where your assets go when you die if you haven't directed them some other way.
Sure.
Which I think you should do. And even controlling assets from the grave, a will really won't do that. Mostly the will just distributes assets out. Could you have a trust built in the will? I suppose you could. But that doesn't really help you the same way as a separate trust would. So a will's really a won't. I think you need to do a lot more than that.
Sure thing. We're talking here with Todd Lutsky from Cushing and Dolan. If you want Todd to answer any of your estate planning questions, give us a call on our studio line, 888-205-2263. Again, that number to call in to ask Todd any of your estate planning questions, 888-205-2263. We are going to take a quick break here, but when we come back, we'll be answering all of your calls to speaking with Todd Lutsky from Cushing and Dolan. That's right after this break.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
We are back here with Todd Lutsky from Cushing and Dolan answering all of your estate planning questions. We're going to jump right into the calls here. Our first call is from Jim in Chatham. Jim, you are on with Todd Lutsky.
Hi, Todd. This is Jim here in Chatham. My question concerns Massachusetts estate tax.
Mm-hmm.
I'm a Florida resident for 6.5 months a year, and up here the other 5 months, 5.5.
Mm-hmm.
My estate attorney tells me to avoid Massachusetts estate taxes on the value of the house, I'd be best to put it into an LLC. And I wanted to just run that by you and see how does that work. I understand that because the real estate's here in Massachusetts, they can tax that, when I die.
How much is the house in Chatham worth?
Probably $2 million.
And the size of the overall estate, roughly, if you added up all the assets?
Yeah, I'm into low 8 figures.
Okay. So what they're going to end up doing is they're going to take so first and foremost, in Massachusetts, folks, for everybody out there, if you move out of state to avoid the estate tax, certainly okay to do that, and you own Massachusetts property, then that Massachusetts property must be placed in an LLC. Otherwise, even as a non-resident, Massachusetts will tax you on the value of the property in Massachusetts. Now, example, if the value is $2 million and your total estate, if the value of the Mass property is $2 million and your total estate is $6 million, then they're going to take $2 million, divide by $6 million, get a percentage, and then that percentage will be multiplied by the tax on $6 million in Massachusetts. So they tax you as a percentage of the whole. So your Mass property is taxed as a percentage of your entire estate. So whoever told you to put it in an LLC, Jim, it is the right thing to do. Understand, once it goes in an LLC, if it was your primary residence, it is no longer your primary residence immediately. You will not get your capital gains tax exclusion when you go to sell that property, but that's okay because you're trying to show Massachusetts that you're not a resident. So putting it in there, certainly confirms that that's not your primary residence. I certainly think it's worth doing, especially with a $2 million size of your property here in Mass. So hopefully that was helpful, folks, and that is very important. And you know what? The guide we're giving away, and it is, by the way, the last chance to get it is the end of the month, folks. So last chance to get it. Potholes in your estate planning, right? Detour ahead, potholes to avoid when you're doing your estate plan. This would be one of them. Somebody who's already got their estate planning done, revisit your estate plan. Not a bad idea. When you revisit it, you will find something like this where, I've moved, so maybe I should revisit my estate plan. And now that I've moved, not only do I need to update my estate planning documents, but maybe I need to look at how it affects Massachusetts, where I used to live. So all kinds of reasons, folks. Second marriages, you lose a spouse. There's always reasons to revisit your existing estate plan. And if you've not done your planning, please get this guide because it will arm you with what to look out for when doing your planning. So 866-848-5699 or go to my website, legalexchangeshow.com. You can download it right there. Folks, it is the end of the month. Last chance to get it. 866-848-5699 or my website, legalexchangeshow.com.
We're going to go to our second caller here with Ask Todd. This is going to be Greg in Boston. Greg, you're on with Todd Lutsky.
Thanks for the program, guys. Todd, ran into a situation where the spouse, we had a mutual financial planner. The spouse was able to go in and change all the beneficiaries without notification to the husband, and then subsequently passes away.
Designated beneficiaries on what? On IRAs, on brokerage accounts, what?
All three. Both of them.
Okay. Go ahead.
Is there liability on the broker, the financial planner who did not inform the unknown spouse? And if so, what actions can be taken?
So definitely a tough situation. So if they were married, I don't know, if you're listed on the account, this is really going to be a function of looking at, the brokerage house and their operating, agreements that they work under. So if the account is jointly owned, well, it may be that either party can change the designated beneficiary. So I don't know that. If it required both signatures to change the designated beneficiary on the joint account, then yeah, I guess there could be some kind of an action that you might want to bring against the brokerage house. Just don't know. Now, from an IRA perspective, those are individually owned. As I understand it, an IRA beneficiary can only be changed by the owner of the IRA, the participant of that IRA. So if that was the now deceased person, and they never actually signed to change it, I would say that's probably just an invalid change, and it would maybe just be ineffective. Whether you have to bring a lawsuit or not, I think it would just be an ineffective change, and it would be like as if it never happened. But again, I don't have the exact answers on something like that. But definitely, folks, that's something to be careful about, especially if you're getting a divorce. I don't know if that's what's going on here. Always be careful and make sure you change your beneficiaries on your own right after the divorce so that you can not have something like this happen. So I'm not sure that was helpful, but I hope it was.
Todd, how often do you feel that you should be reviewing trust work that you've done? Is that something that's an annual process, or how often do you tell people to kind of review what work they've done? Yeah,
I think it's a great idea. So let's take these examples right here, right? The two callers that we had, I think, are perfect examples of something like this. So I'm not sure I quite understood the second one where they're getting I don't know if there was a divorce there or the spouse just changed it and then somehow the person died. That they changed it on. But number one, if you're getting a divorce, please, go out, make changes. If you can change before the divorce, which I don't know, if it hasn't filed yet, I guess you still can move assets. But you got to be careful if you're doing it in reaction or in conjunction with a divorce. May or may not be effective. But certainly after the divorce, you're a single person. Mm-hmm. So if you're a single person, you really need to do your plan as a single person.
Right.
And you need to step back and say, all right, not only do I want to change my beneficiary so the Greg situation doesn't occur, I put on there who I want to be my beneficiary, but you need to now rethink your will, your trust. I'm older now, perhaps. Maybe I want to switch, maybe I want to make sure I have a revocable trust in place for my family and to ensure it goes to my family and not my ex-spouse. So that would be a reason. Take the Jim call. I moved out of state. Well, that's a great reason to change your plan. Now, when you move out of state, your trust may still be okay, but you should change your basic documents, your will, your healthcare proxy, your power of attorney, your HIPAA form. These are state-driven, and they're less expensive to change, but you should change them to reflect the state that you're in. And in addition, it helps you show your intent to be a resident of that state.
Sure.
I didn't just move. I've now changed my voter registration and my estate planning documents. So that would be a reason. What if I lose a spouse? Well, I'm single again for a different reason. Now I need to revisit my estate plan and figure out how to leave it. What if I get remarried? Well, that happens all the time, right? So if you get remarried, you want to make sure that it goes the way you want it to go to protect your side of the family and your current spouse. So lots of reasons, folks. Get the guide. It's the last chance. 866-848-5699 or legalexchangeshow.com.
Todd, thank you so much for the time today. We appreciate it.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing and Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com.